So if Furry Puppet doesn't own the underlying copyright because they didn't have a work for hire clause in there and it was part of an audio-visual work, Fall Out Boy might own the copyright on those puppets. They should talk to their lawyers about that. This is a lawsuit that was filed Friday the 15th, the Ides of March. Didn't you know that you shouldn't file llama lawsuits on the Ides of March? This is Furry Puppet Studio Inc. versus Fall Out Boy. I'm not sure which one of these people is the boy in Fall Out Boy, but they've also sued Peter Wentz, Patrick Stumpf, Andrew Hurley, and Joseph Troman, and a bunch of publishers.
They're all the boys.
I know, I'm just kidding. This lawsuit concerns defendant band Fall Out Boy's widespread infringing exploitation of plaintiffs' copyrights and intellectual property. This is not the first time Fall Out Boy has taken an artist's creation without credit or compensation. I would actually try to strike that second part of that first thing, because that's kind of salacious. Does it really add anything that they've been accused of copyright just infringement before? I don't know. Only maybe this, if they were accused of this copyright infringement before, I don't know. Plaintiff Furry Puppet Studio Inc., a high-end designer, created 2 wearable llama puppet sculptures, which have now become central. By the way, sculptures are protected differently under copyright law, so that's interesting that they're calling them sculptures, which have become central to Fall Out Boy's identity, brand, and music, and have been viewed nearly 1 billion times on social media and other mediums. And they should be proud of that. That is a very remarkable thing. Still not understanding what it has to do with the lawsuit, other than, I guess, they're popular, so they deserve the profits from it or something. I don't know. We'll get into it. I'm only on paragraph 3. Plaintiff is a unique, innovative, successful company in Brooklyn, New York, which creates, designs, and makes a variety of in-demand puppets, stuffed animals, plush toys. Plaintiff was hired in early 2017 by the production company Rubric House to provide 2 wearable puppets for the plot of the Young and Menace Fall Out Boy video. So that's what, one song. They was going to provide the puppets for 1 video. Plaintiff Furry Puppet delivered 2 striking and unique wearable llama-like puppets to be used for the Young and Menace music video. The puppet sculptures are instantly recognizable. The puppets were in fact used to create the Young and Menace music video, which was released April 27th, 2017. At all points, plaintiff was told these puppets were for the Young and Menace music video, and no other use was intended or identified by anyone. Okay, wait a second here. I'm already seeing a crack here. That paragraph doesn't say, here's the contract where everyone said this puppet is only licensed for use in 1 video. Not saying they couldn't have said it and had that understanding, but did it reach the level of a contract or license? I don't know. We'll see. Plaintiff takes no issue with the use of the puppets in the Young and Menace project. It is the use far outside the video that is infringing. Okay. This is something that is conceivable when you go to the store and you buy a copy of the Mona Lisa, or I think I used Van Gogh as a example on the Patreon stream. You do have a right to own that copy and sell that copy, that 1 copy, not to make further copies, but along with, like, what's the prohibition on making further copies? It's 17 USC 106. And that also prohibits you from distributing, from performing, and from displaying publicly. So if Fall Out Boy Inc. bought these 2 costumes and had permission to use the costumes in 1 music video, it is conceivable that the license could have only been for the 1 music video and the public performances associated with that, and not for further use. And that's kind of where we're headed here. Let's keep going. At all points, plaintiff retained ownership of the copyrights in the llama puppet sculptures, and no assignment or transfer of rights was ever signed or agreed to. That's important. At all points, plaintiff Furry Puppet, the puppet maker, retained ownership of the copyrights. Another surprising thing sometimes is if you have a wedding and you hire a wedding photographer, you might be surprised. I was surprised to find out that when you pay the wedding photographer, you don't own the photographs at the end of the thing unless you also pay them for an assignment of copyright. That's just how copyright works. When you pay the photographer and you don't want to own the copyrights, you just get a copy of the photographs for your personal use and any licenses that would go along with that. You need to be careful because it is possible to have a very enthusiastically litigious photographer who says you're only allowed to have a book of photographs, and then when you take the photographs and you take pictures of them with your phone and post them on Facebook, that's an unauthorized use or something. That's conceivable under copyright. Subsequently, plaintiff became aware that Fall Out Boy was using the llama puppet creations in a way that plaintiff never intended or agreed to far outside the video the llamas had been made and provided for. Specifically, Fall Out Boy is and was exploiting the llamas by infringingly reproducing and displaying the puppets as merchandise, an iPhone app, the face of the band, the face of the 80 Concert Mania tour and album, in 5 additional music videos, and a new album called La Mania, as shown here. And there's more pictures and evidence here. There's llama puppets that are being sold. The llama puppets were on Good Morning America. It looks like they're on various, I don't know whether these are Instagram posts or album covers, or this is an album cover. It looks like they're on tour here. More Instagram posts. Now the llamas have been cartoonized or characterized and hand-drawn and are on merchandise. They're showing an eBay listing here, and they're showing a tour poster here, it looks like. Fall Out Boy has a cavalier approach to intellectual property protections, writing on the La Mania album, all rights reserved, unauthorized duplication is highly encouraged. The llamas took a life of their own. They were given names by Fall Out Boy, Frosty and Royal Tea, and became de facto members of the band. The scope of infringement beyond the initial video the llamas were intended to be used in is far too large to fully relate in this complaint, given the all-encompassing way Fall Out Boy used the llamas. But the llamas were reproduced, performed, displayed, and copied. Those are each separate section 106 rights in derivative creations without authorization, including but not limited to the following ways. The entire album named La Mania. Llama's likeness is extensively used in merchandising, shirts, plush toys, stickers, keychains, cards, etc. Sold in major chains such as Hot Topic. They became the face of the band's 80 Concert Mania tour, were extensively used in promotional posters, went on to perform in 80 concerts, video introduction that uses the llamas, used the llamas as part of a massive social media push to promote the band, Mania tour and album, hundreds of millions of views, and currently a banner photo for the Fall Out Boy Facebook page. The llamas were featured in multiple music videos on Vivo, 24.5 million views on Hold Me Tight or Don't, 23 million views on Last of the Real Ones, etc. Heavily used to sell the Mania album, various remixes. They performed and were displayed on Good Morning America, etc. Ellen Late Night Show with Seth Meyers, the app called Emoji in the Apple iTunes Store, and album art for the complete collection. Pete Wentz is clear on defendant Manhead's website, the band's merchandiser, that the images associated with the band are integral to promoting and selling music. Quote, "We have always seen the merchandise and clothing aspects of our band as having a through thread to the music." Thorough thread? Through thread? I don't know. "We have envisioned it being one vision that is unique and strange and singular unto itself." This precisely describes how the llamas are used by Fall Out Boy. The llamas are on track to be viewed 1 billion times if they have not already passed that number. One of the llamas was the fourth most popular GIF in 2017 with 197 million views. It now has 250 million views. All told, the llama GIFs and promotion by Fall Out Boy has at least 620 million views on social media, etc. So this is another 125 pages long, so let's sort of skim through and see what it's about. They're saying that the llamas are original creation of Furry Puppet, the plaintiff. They go into a lot of detail about... Here, I'll do it with page down instead of scrolling. A lot of detail about the various ways the merchandise was used. Hopefully this is a lot of the 100 pages. So you can see that these puppets are obviously used a lot. And so if there's no agreement as to how these llamas were meant to be displayed, then the defendants might be due to pay the plaintiffs the proper licensing fees and profits and such that they've received from using the llamas. This gets complicated, so I kind of expect the plaintiffs and the defendants to talk it out and settle the case, because there will be various arguments as to how much money, when you start with licensing fees and then direct profits, indirect profits, and then costs and punitive damages and attorney's fees and all that. Can you think of in your head like what a number would be? No, you can make up a number, but no, you would really have to sit down and say, okay, well, how much did Fall Out Boy make, and how much did they make before the llamas, and how much did they make after the llamas, and how much of that's attributable to the llamas, and then do we add something onto that because they didn't get a license? It becomes a complicated situation. So that's only 50 pages into the lawsuit. We finally got to where they're asking for some relief, and then we get to a parties section. So we're going to stop there. Aside from, I'm going to quickly page through it. They spend many pages naming the parties, and then many pages on the counts. Let's go through the counts real quick here. So that was direct, I guess that was all direct copyright infringement. And then this one, okay, so there we go. Count 1, copyright infringement. Count 2, contributory copyright infringement, which is when you contribute to someone else's copyright infringement. Vicarious copyright infringement, sort of when you enable someone else's copyright infringement. Inducement, another form of making somebody else infringe. Declaration of authorship, that's sort of a declaratory judgment that Furry Puppet owns their puppets, owns their copyrights. Accounting, declaratory relief, that there should be an accounting. Believe it or not, a copyright owner is allowed to request an accounting from their licensees. If the licensees do not provide an accounting, they can get one ordered by a court. Constructive trust, interesting here. Defendants have profited greatly and are therefore holding their profits in trust, holding the plaintiff's profits in trust constructively. Interesting. Breach of contract is probably the biggest one here. Now, this is an interesting point to make here. So you see here we have a count 8 for breach of contract, but we had a whole bunch of counts for copyright infringement before. Well, if it is breach of contract, it probably can't also be copyright infringement. I've encountered this before. If you have a license for something, which we saw earlier, it looked like they had a license for the Young and Menace video only, right? So if they've used the copyright outside of the license, is that copyright infringement? No. It is a contract violation. It is a license violation. So I think there's a strong argument that there's been a violation and that it's a license violation. And they've included all this other stuff because spaghetti at the wall. That's usually used as a defense, but here it's being used as an offense. You throw spaghetti at the wall, something's going to stick. So here, maybe they've thrown 8+ counts at Fall Out Boy. Well, somebody along the way is going to settle this case. It doesn't really matter whether you've got 8 or 12 or whatever counts. You've got a strong enough case to begin with. But in my humble opinion, if this were to go to court, really what this is a breach of contract or license violation. And it cannot be both a license violation and copyright infringement. As far as my research has found, if you've violated the terms of your license, if you've gone outside the terms of your license, then yes, you're in violation of your license. And you don't get both damages for the license and copyright infringement. I could definitely hear the argument that it's also copyright infringement, but would you really be getting an award for a violation of the license and a violation of copyright? I don't know that those things stack like that. And I would be interested to hear any counter arguments, because I'm pretty sure about my research here that you can't really get both. So I'm thinking that this is really a breach of contract issue.
And there are certain practical considerations, like contract law is often a state issue versus copyright is federal, and copyright has not automatic damage, statutory damages. I'm not sure breach of contract does. So there are some like practical differences between the two approaches to asking for relief.
All right, so other violations, allegedly unjust enrichment, which is another thing you can sue for. I believe unjust enrichment is a common law thing. It could certainly have been codified in various places, but what unjust enrichment means is that you were meant to profit from something in one way, say the Young and Menace video, but instead you went outside your agreement and you profited unjustly. This is an alternative to breach of contract, I guess, in this case. And then they ask for actual damages, profits, statutory damages, contract damages, injunctive relief. They're not going to get all of this. I really do not believe that you can get contract damages and copyright damages in the same for the same claims. I do not think so. Punitive damages, maybe, if this was done, it's entirely possible that they didn't think that they had any sort of limitation on the public performance of these things. And we certainly haven't seen what Fall Out Boy's response is, at least not as of the recording of this video, as of Sunday morning. It's perfectly possible that they're going to come back and say, no, we have an email that says use them for whatever, and so we really thought you meant whatever. I don't know. I really don't know what it's. They could also be in violation of copyright. If they're in violation of something, I think the primary claim is contract. I think that's going to be the primary claim here, because it's not that they went to the store, bought 2 Llamas costumes, and then went and used them all over the country and world for their tour and band and marketing and all that. They went to the store, bought 2 Llama costumes, got permission to make a video, and then went on to. So that changes the whole thing for me, because now they are in violation of their agreement. In the first hypothetical, where they didn't get an agreement, there was no agreement to violate. So there's your copyright infringement. There's your path to copyright infringement. But if they get an agreement and then go on and violate that agreement, I think you can't get a copyright infringement judgment after that. But that was my research in several copyright infringement suits that we've researched over the years. It's possible something has either changed, or maybe that was only in my districts or my appellate circuit. Maybe this is where is this? Let's see. This is in the Southern District of New York. No, I'm pretty sure this is good law in New York, what I'm talking about here. But again, I'm here, a sideline quarterback. I'm not even involved in the thing. So we'll leave it to them to figure out. But I'm going to guess that we're going to see either a settlement or at least a motion to dismiss or / motion to strike some of these claims, because you simply can't have all this infringement and contract violations. My humble opinion, my professional opinion. But okay, but let's back up a second. Those costumes are pretty cool, right? Those are freaking awesome looking llama costumes. I can totally see why they're popular when paired with Fall Out Boy, who is also kind of an edgy band. Or are they still edgy? I don't actually know them very well anymore.
No, they are firmly not edgy anymore.
Like I was gonna say, I think my edgy years were about 10-15 years ago, and I'm pretty sure Fall Out Boy is the same age as me, so.
Leonard, I have to say that this is the prettiest looking legal paper I think I've seen in recent memory.
It is. I would like to know what font they're using.
I love the font. I love the way it's laid out. I love the heading.
Are they using Baskerville? Is that what this font is?
I don't know what it is, but this is like I love the way, like, on their first page, how they have like the complaints enumerated on the right.
It's not Baskerville.
This is the prettiest looking legal document I've seen, and I'm going to rip them off forever because it's just great.
So say if the situation were the band asks for a commission, essentially, and they're like, hey, we want you to design these things for a music video, and there wasn't a contract that said that basically there wasn't a contract assigning copyright. If you ask someone for a commission, does the person who makes it still automatically own the copyright? Because I think we've seen in other cases that when it's part of a larger audiovisual work, that it counts as contract for hire, and
that's true.
Necessarily.
That's true. So there is a thing in copyright work for hire where normally a contractor, which this would be, it does not sound like Furry Puppet Studios was employed as in an employer-employee relationship. So it would be a contractor, which means that a work for hire would have to be explicit if the copyright was assigned. However, there is that thing about if it's part of a larger audiovisual work that it doesn't need to be further assigned, and it flips that. Let's bring that up here. Let's see what the Copyright Office has to say. Made for hire is created when an employee does part of it. When a certain type of work is created as a result of an express written agreement between the creator and the party specifically ordering it or commissioning it. Whether a work made for hire is determined by the facts of the situation. We just read this part over there. The definition is here. A work specifically ordered or commissioned for use as a contribution to a collective work. I don't know that we would call it a collective work, but we might call it a motion picture or audio-visual work. It's clear that Fall Out Boy is a band, and bands do not just play music. It's a visual performance as well. Right? I mean, is there a dispute here? Maybe there's a dispute here. Maybe we don't think that a band is an audiovisual work. Maybe it's strictly a musical work. But let me at least with this hypothetical have that a band could be considered an audiovisual work. Where does it cross over into having that protection or not? Let's see. An audiovisual work down here is a work consisting of a series of related images that are intrinsically intended to be shown by the use of machines or devices together with accompanying sounds, if any. This definition holds regardless of the nature of the material objects in which the work was embodied. So this was meant for a music video, which would be an audiovisual work. In which case, a work specifically ordered or commissioned for use as part of an audiovisual work is a work made for hire.
So they would need to produce a contract showing that they retained the copyrights.
Yeah. So then how does it work if it doesn't say it's a work made, well, let's pretend the contract does not say this is a work made for hire or not, or this copyright is assigned or not. Obviously, Furry Puppet thinks the copyright was not assigned, so I think that's a pretty fair assumption. So let's say that the contract, it sounds like they don't even have a contract. Let's say that their emails going back and forth are silent on this point. Do we agree that there's a license agreement for this? I'm not sure. We also have something called the Statute of Frauds, which means that contracts over a certain dollar value need to be in writing. Maybe there's enough text messages and emails going back and forth to constructively constitute a contract. We would call that a quasi-contract, or it could actually reach the level of a written contract if it's in enough of a written form. So let's say that they had enough of a license agreement to form a contract, but they were silent as to work made for hire. However, the license agreement clearly says you're only allowed to use these things for the video. This one video, Young and Menace. I think Fall Out Boy might still be in the right just because this contract is silent, or just because the contract was for Young and Menace, the contract was silent on the work made for hire provision. Wouldn't that mean that Furry Puppet never had a copyright to assign and license? Since it didn't have a work made for hire provision retaining the copyright in Furry Puppet, Fall Out Boy would have had the copyright outright from the beginning, the moment the contract is signed, probably even the moment that the puppets are delivered, if there was no signed contract. So if that's the case, is it even a contract violation? You can't contract for something you don't own. So if Furry Puppet doesn't own the underlying copyright because they didn't have a work for hire clause in there and it was part of an audio-visual work, Fall Out Boy might own the copyright on those puppets. They should talk to their lawyers about that.
And I think it's a lesson for any of the viewers that do commissioned works that you should be clear about who owns the copyright when it comes to commissioned works, because if you want to retain the copyright, you need to agree to that beforehand, and preferably in writing.
Yeah, Leonard, I own all the copyrights for all the videos on Lawful Masses.
Let's see here. Specifically ordered or commissioned works are considered work for hire if it satisfies all 4 of the following criteria. 1, the work must fall within the 9 categories. We saw the 9 categories, and we agree that regardless of whether Fall Out Boy is a band and these were going to be used for performance on stage, they were originally commissioned for use in an audio-visual work. So the work must fall within the 9 categories, and it does just because they were commissioned for the music video. 2, there must be a written agreement between the party that ordered or commissioned the work and the individuals who actually created the work. So it's going to be this is going to be important. If there's no written agreement, then it's not a specially ordered or commissioned work, as shown up here under Section B. In the written agreement, the parties must expressly agree that the work is to be considered a work for hire, and the agreement must be signed by all parties. If a work fails to satisfy these requirements, it is not a work made for hire. So this one's right on the line there. We don't know if they have a signed agreement or what's considered signed. Is it signed if you agree to it via email? I don't know.
Surely if they had a signed agreement, they would have included that as an exhibit on their complaint.
Yeah, so it sounds like they have maybe an email agreement. So this might not... I don't even know what this is. There's some kind of quasi-contract here. It sounds like this is a breach of contract at best. And it sounds like at worst, it's a copyright made for hire and Fall Out Boy owns the copyright. It's one or the other, and it's kind of right on the line. Thank you very much for joining us today for this video for our show. I love you all. I am Leonard French, your favorite copyright attorney. This is a community-supported channel. We are mostly supported by Patreon supporters, by Twitch subscribers, and by YouTube views. We'd like to get the YouTube subscriber thing going. We're currently working on getting our channel partner manager assigned and all that, and then I'll reach out to them and ask when we can possibly get our YouTube subscriber thing going as well. We use your money to pay our editor, our researcher, to offset our costs, and to keep and to offset my time for producing these videos and taking the time to run the channel and all that. You can support us at patreon.com/ljfrench, and we accept support on the monthly basis. So if you support today, you'll be charged for April, and you'll appear on the supporter lists for April, assuming that you leave your pledge in place until April rolls around and you get charged on or about April 1st. What I'm saying is that the supporters for March, they started their support before February 28th, midnight, into March 1st, and then got charged on March 1st as official March supporters. So for March, thank you very much to our $50 plus supporters: Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Aspernari. And thank you to the $5 plus supporters whose reward is to be put onto the scrolling LED panel behind me. We're going to be changing that up sometime soon here with a new LED panel or TV screen or something, and we'll do some kind of motion graphics with that and see what we can do there. Maybe it will flicker less in the background as well. And thank you to all of the other supporters, because there are other Patreon supporters, there are Twitch subscribers, there are some people who just throw us money on PayPal once in a while when they see us do something that they enjoy and want to thank us for our hard work. We really appreciate the two-way community that we've got going on here, really appreciate our editors and researchers and participants here, Brandon and Kelly and Tactical Bra. You're all awesome. Thank you very much. Thank you, our audience, for joining us. I am Leonard French, your favorite copyright attorney, and I will see you in the videos this week. Love you all. Bye. I don't know. You could just destroying a passport is not necessarily a denouncement of citizenship.
Like burning a flag, right?
Well, burning a flag is a free speech thing. The government can't make a law against that. You might not like it. You don't have to associate with that person, and correct. There's probably even you can probably even get away with not hiring a person who burns flags.
Right.
You can probably have as a corporate policy, we don't hire people who burn U.S. flags. That sounds like something that's okay.
So is it legal then for a prospective employer to go on Facebook and see that you are out partying and drinking and carousing and whatever, and say that we don't feel that you are an exemplary employee and we don't want to hire you?
Well, yes, absolutely. It's also perfectly legal to say I don't want to hire people who drink alcohol, as long as these policies are uniformly applied. They cannot be unequally applied.